Should be good.
All rise. The Court of Appeals, First Appellate District of Ohio is back in session. Please be seated.
All right, the next case on our docket is C-240430, Zhang versus Zhang. Is counsel for appellant ready to proceed?
Yes, good morning, Your Honor. Nick Pazonka and Spencer Cowan, we are ready to proceed. I'm sure you guys were briefed on my troubles this morning, but I appreciate the accommodations, but we are ready to go.
We were. Glad you're here. Thank you. And is counsel for appellee ready to proceed?
Yes, Your Honor.
All right. Counsel for appellant, you may come forward. Would you like to reserve time for rebuttal?
Would like to reserve 2 minutes. Thank you.
All right.
May it please the court, counsel, Nick Pazonka on behalf of the appellant King Yu Zhang. And again, apologies for this morning. I might be a little bit more tied to my outline than I would like to have been, because I plan to go into the office and prepare for this a little bit this morning. But I of course, got sidetracked. So before we get into the legal arguments, because a lot of this turns on the facts here, and I want to highlight some of the facts. A little bit about our client, which we refer to in first names because there's a little bit similarities in the last names. So King Yu, he is 80 years old. He speaks no English, despite what Veronica wants this court to believe. And at the relevant time, King Yu trusted both Veronica and Sean, in his words, immensely. And I think that's really important here when we're dealing with fraud and trickery in the signing of documents. And a little bit about 2000 West, the company. In 2017, King Yu, Veronica, and a third party created 2000 West. At its inception, King Yu held a 50% ownership interest. Now, there's a question here over King Yu's initial contribution in the company. He says it's a capital investment. And Veronica says, no, it's actually a loan that I gave you to make that capital investment, $500,000 personal loan from Veronica to King Yu. That's important when we get to the consideration argument that I'll get to in a minute. But we think that that is a post hoc argument after the fact. There was no loan. There are no checks from Veronica to King Yu. There are no repayments. What we have are...
What about the checks to the trucking company?
Yeah, to New Diamond, a separate entity. Nothing documenting a loan from Veronica to King Yu at that time that she says it was made. There are documents that are after the fact that Veronica backdated, which we think, creates a red flag, right? Smoke that we think should be submitted to the jury of whether or not this was valid or was an initial contribution or a loan. Now, 2000 West was a real estate holding company.
Are there facts in the record that would create a dispute as to the transfer of money from Veronica to the trucking company? Or is it undisputed that that happened?
There are 3 checks, yes, that total $500,000 that went to the trucking company that were all after the fact. So the company was created in 2017. The checks that were written, and there is a question of fact of whether Veronica was actually an investor in New Diamond. It's our position that those loans, or that money, was the form of an investment in New Diamond and had nothing to do with a loan. And there is testimony to that effect.
You're saying it was these checks came after the 2019 document was...
Not after 2019, I think it was 2018. 3 separate checks, and those are in the record. Do you have the dates? Yeah, 3 successive dates, 3 successive checks after 2018. I apologize.
But it was before the 2019
Correct.
amendment. Okay.
Yes.
And so she's saying that the check, that money was a loan.
That's what she's saying, yes. And we're saying the complete opposite, with, I think, very good reason to. I mean, 3 checks to a separate company, not to him. No loan documents created at the time. No repayment schedule. And in the amendment itself, there's no recitation that this is what he's transferring his membership interest for.
And so it's your position that this dispute of fact goes to the consideration for the 2019 amendment?
That's one of the disputes of facts, correct. The other one is fraud. And if I can get to the fraud argument, again, the
And
facts.
I just want to make sure I understand. So it's your position that a jury could go either way?
Correct.
A jury could believe Veronica and say, yes, this was a personal loan, and therefore there was consideration for the 2019 agreement. Or they could believe Kingu and say, no, that was a whole separate business endeavor, and there was not sufficient consideration.
Yes, absolutely. So 2 arguments to contest the 2019 amendment. That is one, fraud, based on what he was told and what was represented to him. So remember, he speaks no English. This 2019 amendment is all in English.
So it's his word against theirs.
Correct.
Yeah.
Yeah, I mean, which, is what juries are for. So we get to put on our case, they get to put on theirs, they get to cross-examine him, get to cross-examine them, and, it's up to the jury to decide. That's why we have the system that we have.
What about the argument that the 2020 affidavit incorporates the 2019 amendment?
So 2 things on that point. Let's look at what the 2020 affidavit actually says. It says, I arranged to do this. It's not that I did that. But the bigger argument there is that the fraud argument with respect to the 2019 amendment is fraud ab initio from the outset. Okay? It's as if we're right and there's a question of fact over the fraud, it never took place in the first instance, and you can't revive something that never took place. So one, sure, the amendment is attached to the 2019 or the 2020 affidavit, but
Isn't there an argument that, if believed, that the 2020 document undercuts the notion that there was fraud in 2019? Because if someone is going to, in front of a notary, sign an agreement that incorporates a different document, they wouldn't do that if they thought that was a fraudulent document. Can you respond to that?
yeah, of course. One, it's not in English. Nothing, and I think it's quite telling if that 2020 affidavit says that it was transcribed for him in English. Somebody told him or translated it, and Veronica, in her discovery responses, admitted nobody translated that to him. So that 2020 amendment, even though it attaches it, it would have no legal effect on the 2019 amendment. It can't resuscitate that. It didn't exist. And secondly, the 2020 affidavit has to be supported by consideration.
What did he testify that he thought he was signing in 2020?
2020, he didn't remember. So that's the distinction between the 2019 amendment and the 2020 affidavit. 2020, we have in the record him saying, I thought that they were represented that this was a tax document. In the 2020, he just didn't remember. 2019
Was a tax
document.
2020, he couldn't remember.
Couldn't remember.
What was his explanation for going ahead and signing it in front of a notary?
That he trusted him. I mean, remember, they referred to him as uncle.
But did he describe the circumstances surrounding that? I mean, did they bring a notary with them, or
Took him to a notary.
Right, took him to a notary.
Correct.
And so he just said, he can't remember what they said about the document. It was in English. He didn't know what it said, and he just went ahead and signed it in front of a notary?
Yep. And again, all points for cross-examination, that I fully expect them to question him and say, oh, this was just another document that you claimed you were defrauded in signing. But the Imperial case is the important one. That's the case that we cited where a salesperson went to somebody's home, and I think it was a replacement of carpet or something, and he was led to believe that it was just an estimate, that nobody misrepresented that this was what it was. He was just led to believe on the surrounding circumstances that this was what it was. And the individual, the homeowner that signed that what he believed was an estimate, was not proficient in English.
Was your client led to believe something here?
Yeah, absolutely.
What did he say? Because he said he couldn't remember, right, for 2020. Did he say what he was led to believe?
He said he would not have signed that because he did not owe anybody $500,000. So he didn't think that what he was signing was an affidavit releasing his rights.
He can't remember anything, and so he didn't testify that he was led to believe anything.
What he testified to is, I can't remember what I signed.
Okay, all right.
So,
The Imperial case, though, when it comes to the 2020 document, the Imperial case talks about the fact that the other party lied about the contents. It also mentions the language barrier, but that was only one of the factors, correct?
I don't remember an actual affirmative misrepresentation. If that's what Your Honor is saying, I'm not questioning that. but it was the led to believe. And I think the surrounding circumstances here was that, and I think I quoted this in my outline, that the actual holding was that he wasn't proficient in English and was led to believe he was signing something he wasn't. But I fully acknowledge we can't point to, yes, you thought you were signing this and you didn't sign. That's not what you were signing. That's not in the record. And that's why I think the consideration argument for the 2020 affidavit is the important one, because what they say is now the consideration is that he just gave up his membership interest and all the burdens that came along with the membership interest, and that's what Veronica assumed. So taxes, maintenance, property insurance, things like that. So when I was preparing for this, I was like, okay, let me think of a good analogy. Let's say I own a car, right? I have to fill that car up with gas. I have to pay insurance on that car. I have to maintain that car. I've got to replace tires when they pop on the highway on the way to oral arguments. Let's say I want to sell that car, and Your Honor approaches me and says, I want that car, and I just give it to you. Is the fact that I no longer have to pay gas and maintenance and insurance on that car, is that sufficient consideration for me just giving it to you? No, that's a gift. And that's what they're saying, that he gave the LLC interest in that 2020 amendment or affidavit, because what their position is now that the 2019 amendment is completely irrelevant to the situation here.
Counsel, there's a couple of ways for us to look at that 2020 document. One is in terms of its potential contractual relationship between the parties, right? And I think that's why you're addressing the consideration element. Another way that we might look at it is in terms of its evidentiary value, right? Setting aside whether it constitutes a contract or not, it might provide evidence. And how would you respond to me, well, let's assume that your opponent might say that 2020 document, whether it's a contract or not, is evidence of the contents of the 2019 document and that it was signed voluntarily because the 2020 document incorporates it. How would you respond to that?
Again, it's the void ab initio. It's you can't revive something that never existed. So while it might be evidence of it, you can't say, okay, I signed this document and it later revives something that never existed. That's the whole fraud in the fact and fraud in the execution. If he was duped into signing something earlier, he cannot later revive that. He can sign a new document or something with valid consideration supporting something like that, but simply signing an affidavit after the fact that said, I arranged to do that in the past, even though I was tricked to arrange to do that, doesn't mean he in fact did that. So that's the critical piece of that argument there. And I don't know if Your Honors want me to address the sham affidavit argument. I think that's a little misplaced under the circumstances. So typically, as I'm sure you're all aware, the sham affidavit is the typical way it comes up is something happens.
Along that line, could you help me understand the sequencing of the deposition? So had that been scheduled by your opponent prior to the filing of the summary judgment, or why did that occur after the fact?
I do not remember the sequence of that, but I can say that they did file a summary judgment. They did want to take King Yu's deposition. I don't know if at the time they filed it, they had wanted to already expressed an intention of doing that. I just know that, they did file the summary judgment. His deposition was taken after the fact. But that was on their choosing. They were the ones that wanted to do that after the fact. And it's not like he then submitted an affidavit after his deposition that contradicted something in his deposition. That's the typical way a sham affidavit comes up. So taken to its logical conclusion, what they're basically saying is, if you're tricked into signing an affidavit prior to filing a lawsuit, you cannot testify about, why you were tricked. Because you can't say, oh, this happened, because it would contradict your affidavit. So that's what they're really saying is that, if somebody signs a pre-suit affidavit, they're stuck with it and they can never contradict it or cannot explain the reasons why they were tricked into signing something. And that's not the purpose of the sham affidavit rule. So I know I haven't stuck to my outline at all. I think I've hit most of the high points. I don't know if Your Honors have any other questions. I hope I addressed them all. Okay, thank you.
Thank you.
May it please the court, Nathaniel Truitt on behalf of defendant appellee Veronica Zing. My friend on the other side has asked this court to believe that it's King Yu's word against Veronica's word. That's not the case. It's King Yu's word against King Yu's word. It's King Yu against himself. And to quote the Ohio Supreme Court, this case is about the legal and commonsensical axiom that one must read what one signs. And that principle is precisely the reasoning underpinning Judge Luber's decision to grant summary judgment, because in her words, you're responsible for your own signature for what you're signing, end quote.
Well, isn't that true to a point? I mean, doesn't a person have to be given an opportunity to look over the document and a reasonable time period to engage in self-help, especially when there's a language barrier?
I would agree, Your Honor, and I think that there are two key undisputed factual issues here that go to that. The first is that King Yu did have the opportunity to read. And in fact, at the summary judgment hearing, counsel for King Yu told the court, quote, King Yu relied on his son, who does speak English generally, to help translate certain documents, end quote. And that's generally supported. That's why King Yu's counsel made that concession. The second is...
Wait, to help translate certain documents?
Correct. So
Not the 2020 document or the 2019?
In particular with the 2020, to stay with undisputed facts, the affidavit was text to King Yu's son 2 days before he signed it. And that's in TD 42, Exhibit B, is where you find that affidavit.
So he received it 2 days ahead of
That's
time?
correct.
And then the testimony was that he did use his son, not necessarily for this one, but he has used his son for prior documents?
Correct. In fact, that relationship goes pretty broad, because at his deposition, when asked, quote, does your son Tom have authority to speak for you on all matters? He answered, yes, generally yes. And so the course of conduct was that Tom spoke for him, Tom translated for him. So when
So
Veronica...
that creates the opportunity to review the 2020 document.
That is correct, Your
And
Honor.
what about the 2019 document?
So
What's
the
in
tw-
the record about that?
So also in Veronica's husband's affidavit in the same place, and in Veronica's affidavit, so I believe it's paragraph 29, there was also discussions with Tom, and Tom corresponded back to Veronica to say, yes, we will make sure that you don't lose money. We will give you King Yu's ownership interest. And so on both documents, there is corroborating evidence from King Yu and or his son, or I guess I should, to be more precise, from King Yu's son speaking on his behalf, corroborating the story and Veronica's version of events. And if I could...
So there's evidence, I just want to paraphrase what I'm hearing from you to make sure I understand. There is evidence in the record with regard to the 2019 document that there was some back and forth negotiation leading up to its preparation. Is that correct?
That is correct. It is paragraph 29, and Exhibit 7 is pictures of the screenshots. Of course, the text messages are in Chinese, so Veronica's translated, but they have never disputed those translations. Tom messaged back to Veronica to say, regarding your $500,000, I can give up King Yu's stock in 2000 West as either collateral or refund in order to secure your investment, end quote.
And then what about any evidence that King Yu had an opportunity to review the document that was ultimately prepared?
So with respect to the 2020 affidavit, I think it's important to note that when Sean texted a picture of it to Tom, he responded back to say, I need to consult with the attorney. We will do what we agreed to. I'll call you after I see the attorney tomorrow. So that was August 11, 2 days beforehand. Then the very next day, King Yu's wife independently calls Veronica and leaves a voicemail in which she says, Veronica, tomorrow you go with Tom's dad to notarize, anytime is fine. And then Sean separately reaches back out to Tom to make doubly sure if everything was good. And he asked if King Yu could, quote, go for a notarization tomorrow, end quote. And Tom replies back, sure. So both King Yu's wife and his son are independently reaching out and confirming King Yu's assent to that 2020
Okay, that's
affidavit.
the 2020, but what about the 2019? I mean, his version of what happened in 2019 is very different from Veronica's version. And so what evidence is in the record to show that he had an opportunity to look at that 2019 document and actually meaningfully review it before he signed it?
I think the evidence is fairly sparse in that regard, other than what I've highlighted with respect to the negotiation and discussions confirming it, except that I would say that Kingu under oath has affirmed in 2020 that he did in fact review it, that he did in fact intend to transfer his membership units, and has affirmed the legitimacy of that.
So that 2020 document helps us from an evidentiary perspective defeat his version of events as to what happened in 2019. Is that your perspective?
That is correct, but I think it's twofold. From an evidentiary perspective, it would be much like some of the cases we cited. There were two in particular where we cited where prior testimony contradicted self-serving testimony in the current case, and the courts dismissed those under basically a sham affidavit corollary. So that would be the one side, the evidentiary perspective. The other is that it would be a contractually binding release because it was supported by consideration. And with respect to the consideration, it's Article 7.2 of the operating agreement, which is in Exhibit 1 of the MSJ. I think it's Sub-Exhibit 2. It expressly says that no transfer of ownership interest between the members could be final or official unless all the members consented. And so there's really no legal dispute here that until Kingu signed the affidavit and Veronica then signed the amendment affirming that she was agreeing, the transfer of Kingu's membership units, the forgiveness of the debt that he affirmed that he owed under oath, those two things could not happen as a legal matter. Now, as between Kingu and Veronica, it may be decided that that's both what they're intending, both what they're committing to do, but neither of them could enjoy or take the benefit of what they had bargained for until Kingu signed the affidavit and
Well, isn't their position that that is entirely hearsay? Can you help me understand why it's not?
There are two reasons why it's not hearsay. The first is it's paragraph 35 of Veronica's affidavit. She just says, Ms. Liu essentially requested or demanded confirmation that Kingu intended to transfer his membership interest. That statement is not being offered to show that Ms. Liu subjectively wanted to know whether Kingu wanted to know Kingu's intent. So it's not being offered for the truth of the matter asserted. It's being offered to show that she objectively made the demand, and that's all that's required to show that it was a condition of negotiations. But even if Veronica was offering that for the truth of the matter asserted to show subjective desire on Ms. Liu's part, it would still be admissible under the Evidence Rule 8033 exception for a statement of a declarant's then existing state of mind, such as intent, plan, motive, or design. And so either way you look at it, it would be admissible. And I would also note that Kingu did not raise this issue below, and it was on the bottom of page 5 into page 6 of Veronica's motion for summary judgment. She expressly said that it was a condition, and it was supported by Veronica's affidavit. And to suggest that Veronica did not rely on this below is belied by the fact that Kingu's brief in pages 20 and 21 cites to Veronica's opening brief of her motion for summary judgment, both the brief and or both the motion for summary judgment and Veronica's supporting affidavit. So the fact that they are citing to her opening brief below shows that we did in fact rely on this in support of her motion. And so it was in fact waived as an argument because neither Veronica could address it and offer different evidence if Judge Lubers had decided it was inadmissible hearsay, and of course it was prejudicial and unfair to Judge Lubers as well. I would also like to add, though, on that issue, there are two prongs of support to show the consideration. The first, of course, is Veronica's testimony. The second is the timeline of events themselves. Ms. Liu sued Veronica and the LLC, and it's important to note that she sued the LLC because as a result, as a member, King Yu was then facing potential repercussions of any judgment against the LLC as a then legal member. And so he sued in May 5th, 2020. King Yu signed the affidavit August 13 of that same year. Roughly 2 weeks later, on August 30, Ms. Liu signed that amendment. And then the case was dismissed 2 weeks after that.
And that's all in the record.
Everything is in the record except the dismissal, unfortunately, is, I mean, it's not disputed, and it would be publicly available when the case was dismissed. But the affidavit, Exhibit A to the motion for summary judgment, paragraph 12, and Exhibit 4, that demonstrates when Ms. Liu signed the amendment. And then King Yu's deposition at page 112 and Veronica's affidavit at paragraph 37 both support, of course, when King Yu signed the affidavit. So those timelines would be supported in the record, and then the dismissal of the lawsuit was September 15, 2020.
Can you address your sham affidavit argument? So it's my understanding, looking at the case law landscape, that if we were to agree with you, we would be the first court to hold that the sham affidavit doctrine applies to what I'll call a sham deposition. I want to give you the opportunity to convince me that we should do that.
So with respect, Your Honor, I don't believe that is the case. I think the first one would be Boyd v. Haryani, the 9th District case. No, my apologies. I did get the case number.
It's on page 19 of your brief. Boyd v. Haryani, is that what you're looking for?
No, Cummings v. Lyles. That is an 8th District case. In that case, the defendant pleaded guilty to knowingly intending to harm a boy that he hit with his car because that boy had stolen his son's bike. Then later in a civil case, he offered deposition testimony to say, no, it was accidental. I didn't do it knowingly. It was accidental. And the court discounted his deposition testimony in the civil case to say, no, you can't just offer self-serving testimony that contradicts your prior admission and escape summary judgment. And because if you're going to do that, you have to have, and I think Ohio courts have generally applied this rule, you have to have something corroborating your self-serving statement, and you have to have a sufficient explanation to show why you're reversing course, which of course we don't have here. And the second case would be the North Eagle versus Cosas, also an 8th District case, and that's the truck driver who had admissions that he had made via discovery request, and then shows up at the summary judgment hearing and gives live testimony that contradicted those prior admissions. And there the court affirmed that those self-serving statements that contradicted his prior admissions could not serve to defeat summary judgment. So as I understand the case law, this would be, at a minimum, the third time that an appellate court in Ohio has applied the sham affidavit rule to this type of context.
And the prior statement that you believe he is contradicting or was contradicting in his deposition is the 2020 affidavit.
That is correct, Your Honor.
And there's no other written statement that he made in the course of discovery or something like that.
I apologize if I'm not fully understanding Your Honor's question. Are you asking whether he admitted to having signed the 2019 in some discovery request?
I'm just asking the source of the conflict. So he has testimony in his deposition where he's saying, this was a fraud, I was duped, I can't speak English, et cetera, et cetera. And then he has the 2020 affidavit, which says what it says. Is there some other source of a conflict, or is it just those two things?
As I understand it, it's just those two things. It is his word in his affidavit concerning the 2019 amendment versus his word at the deposition concerning the 2000.
All right.
I'm gonna switch gears on you for a second. Can you, so there are still counterclaims outstanding, correct? At least, the counterclaim for the breach of the, release and waiver, correct?
Correct.
Do we have jurisdiction?
I think the court does, primarily because if the court decides this, everything else goes away. Let me rephrase that, that was not helpful. If the court affirms this, or maybe said differently, Judge Luber's grant of summary judgment, for practical purposes, makes everything else moot. Your question is noted, and I think
Does that
it's a
include your claim that King U breached the 2020 release by filing the lawsuit? Is that not something that your client would want to pursue?
I don't think I'm prepared to be able to answer that question today, but I do think to follow the, with apologies, I don't have a good answer to that. Yeah, whether, because it is an open counterclaim that our client has not dismissed, and.
So there's only one counterclaim left? Is that my understanding?
So our client did have a claim for a declaratory judgment as well, but I would kind of view that as being subsumed in the affirmative one.
Mm-hmm.
And so my recollection is that the counterclaim for breach of the release, which would allow my client to obtain attorney fees, would be outstanding.
And that's all the damages that's being requested is the attorney fees in that one?
That would be correct. It'd be
And that's what appellant put in their brief, and you all didn't dispute that. That there was, the only surviving claim is for breach of the affidavit, and the only alleged damages are attorney fees.
That is my recollection, to be correct.
You all agree with that? Okay.
And so that it definitely does raise an interesting question of jurisdiction. I'm not sure if I have any time or if there's any.
You've reached your time.
Right, thank you.
Thank you very much.
I am going to start you out where Mr. Truitt ended on the jurisdiction.
Yeah,
question.
I do believe you all have jurisdiction, and we cited this in the papers that we cited in front of Judge Luber's when we were trying to get the 54B language. I think.
Right, I've read your memo on that.
Yeah, the arguments are in there. I think we would just reiterate those. I wasn't fully prepared to address that. That was one of the things on my list today to get to, but, I can't use that as an excuse much longer. But yes, I think your honors do have jurisdiction to decide this. I think what we heard a lot of is there's evidence on both sides. There's evidence of this, there's evidence of that. Again, that's the purpose of a jury. There were things that were said to Tom, King U's son, maybe things that his wife said. They will say that, what I said, and this is in the record, Tom was deposed about, we'll give you the 50% ownership interest. That related to the interest that Veronica had in New Diamond. That was the discussion, and that is the testimony in the record, is that the text messages were about New Diamond. And that's why the checks to New Diamond are so important here, because it's part of the bigger story. Was it an investment in 2000 West? The answer from our perspective is no. The discussions later on, okay, well, if you lose your investment in a New Diamond, what are we going to do with our investment, or this 50% investment in 2000 West? That was the discussion surrounding that. The point on consideration about this lawsuit between Jennifer Liu and 2000 West, and then that's the reason that this affidavit was signed. Your Honor should be asking the question is, what did King U personally get? He was not a personally named defendant in that lawsuit. He did not get a dismissal for signing this affidavit, did not get paid to sign this affidavit, did not get some services to sign this affidavit. Nowhere referenced in this affidavit is any mention of what King U received to get this. And then in the affidavit itself, there was questions about, the sham affidavit. I'm sorry, I'm probably running up on time here. Of whether this contradicts anything. In this affidavit, King U does not say, I wasn't duped, and now he's saying I was duped. That would be a direct contradiction, maybe, and have some evidentiary value. He doesn't say in this affidavit, here's what I received as consideration, and now is later saying, I didn't get anything for that. That would be a direct contradiction. That's not what we have in this affidavit. What he's saying is, I signed this thing, which we're not contesting. We're not contesting that he signed the 2019 affidavit.
Does the 2020 affidavit address the circumstance under which the 2019 agreement was executed? So does it speak to whether there was fraud or voluntariness or anything like that?
It does not. I mean, it says, I arranged to do this and I signed it.
All right, and counsel, you're out of time.
Thank you.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. Enjoy the rest of your day.